Hello guys, and welcome to my lecture. On today's lecture, I will be talking about the power holding of the company. Now, when we are talking about power holding, we are basically asking the question, where exactly, when we are looking for certain powers in the company, who has the power to do A? Who has the power to do B? Who can do this? Can he do this? Can that do that? Where can we go to? You see, we need to start first from section 87.1. Because section 87.1 tells us that where the company is to act, the company shall act through the board of director or through the members in general meeting. And don't forget my lecture earlier, I told you that the board and the members are the mind and the will of the company, while the servants are the officers who must get their powers from the mind, which is the board and the members. Do you understand? Now that we know that, okay, when you are looking for power, where do you go to? You either go to the board or you go to the members. The next question is, those powers that we are looking for, how can we know whether, okay, so for example, we want to pass a resolution that we want to sell a company's building. Where exactly should we go and get that? Is that such that it is enshrined in the board of directors, or is that such that it is enshrined in what? The members in general meeting. How do we then get it? We then have to go and read what section 87.2 says. What does 87.2 say? It tells us that subject to the provisions of the Act, the respective powers of the members in general meeting and the board of directors shall be determined by the company's articles. It says subject to the provisions of the Act. First of all, the Act is the first place that we start from. Why? Because whatever the article says, if it's inconsistent with the Act, the article or the memo null and void. We find that in section 723 sub 1 of Cama. It tells us that the articles must not be inconsistent with the Act. So the first place we need to start from is the Act. However, principally, the constitution that governs the internalities of a company is the articles. That is the reason it tells us that where you are going to find the power delineated between the board of directors and the members in general meeting will be in the articles. Do you understand that? As it's seen is section 87.2. However, a provision that I like so much, a provision that gives me so much joy, and I'll tell you the reason it gives me so much joy, is the provision section 87.3. Now, what does section 87.3 say? It says that except as otherwise provided in the company's articles, the business of the company shall be managed by the board of directors, who may exercise all such power of the companies as are not by this act or by the articles required to be exercised by the members in general meeting. I love this provision so much. The reason I love it is because if you are a company lawyer or someone who loves company law and you have been told to draft an article for a company, and then you do not either recognize this particular provision, or whether or not you recognized it, you decided not to take cognizance of it when you were drafting the company's articles, it will by such extension mean that your company article, the articles of the company that you are supposed to draft, would have all the business run by the board of directors except as otherwise stated by the Act. Now, let me explain to you what I just said. Now, I need you to understand that this provision is a default provision. And what does a default provision mean? It means that there must be an enabling provision in it, and not just that, a mandatory provision. What is an enabling provision? An enabling provision is a provision that allows you, that gives you the permission to do something or refrain from doing something. It enables you to do it. However, when you have chosen to refrain yourself from doing that thing in a default provision, it automatically makes that mandatory provision, which is inherent in the default provision, applied or applicable on you. In this case, what is the enabling provision? The enabling provision here is except as otherwise stated in the company's articles, which means that it enables you to otherwise state If you do not otherwise state, it means that the business of the company shall be run by the board of directors. If you don't want the business of the company to be run by the board of directors, then you need to otherwise state. Do you understand what I'm saying? So your enabling provision there tells you otherwise state it in your articles, because if you don't otherwise state it, the mandatory provision there, it tells you that the business of the company shall be managed by the board of directors. Do you understand what I'm saying? For you to understand basically what I'm saying, both section 87.2 and section 87.3, I want us to go through the case of Queens and Athens versus Salmon. I have the case in my notes, reported in my notes, but I just want you to understand what I'm currently saying. In the case of Queens and Athens versus Salmon, what happened is that the power to pass a resolution to buy and sell property had already been given to the board of directors, not the members in general meeting. Do you understand that? Now, the board of directors in that case said that, okay, for us to be able to pass this resolution to buy and sell land in this particular company, the both, because there were two directors, Athens and Salmon, the both of us must say yes. When one person says no, resolution is not passed. In this particular case, one person said no to the sale of a property, and then the other party, instead of agreeing that, oh, there's no resolution, or try to convince the other party to come to terms, he then took the matter to the members in general meeting. The members in general meeting then passed a resolution and then tried to sell the property. But the aggrieved party in this case, the party who said no, now went to court and told the court it is not possible, because the power to do this was not given to the members in general meeting. The power was given to the board of directors, and where the power has been given to the board by the articles, then the board and only the board can exercise it. Do you understand that? And so the court held in the case that where you have taken the power, you have given the power to the board of directors. It is only the board of directors that can exercise that power. The members in general meeting are not supposed to be the ones exercising the power that the article has specifically given to the board of directors. And this is instructive in our section 87 subsection 3, where it tells us that except as otherwise stated by the article, if you want that particular power to be given to members in general meeting, then otherwise state it in the article. But if you don't state it, the business of the company shall be run by the board of directors, except as stated by the act to be run by the members in general meeting. So now we have perused through the power holding of the company. Where do you find the power? And section 87.2 and 87.3 has given us a direction. But now something very interesting is about to happen, but that's going to be in my next lecture, and that is the managing director as a third organ in a company. Who could have seen that coming? Because section 87 sub 1 tells us that we only have two organs. My next lecture, we are going to see the third organ of corporate administration.